Good afternoon, everyone. Thank you for joining me here today to learn all about the basics of New York State partition actions. As Pat mentioned, I am an associate attorney here with the law firm of Tully Rinckey. And actually, I was exposed to my first partition action shortly after joining the law firm. It's an area that I never knew existed, but I quickly discovered a passion for. And actually find myself getting excited to work on these types of files, do legal research, and actually litigate these types of actions. So just generally, partition actions, really, they're very unique, special types of proceedings. And the actions are aimed at forcing either a division or sale of the real property. So next slide. The agenda, I'm going to be covering a couple different topics. I'll be talking about the types of individuals who have standing to bring partition actions, the different methods or types of partition actions, how courts go about, how one should go about filing a partition action, what information needs to be included in the complaints, who must be named as a necessary defendant. I'll basically cover the Uniform Partition of Heirs Property Act, and then last I'll follow up with factors that courts typically consider when allocating the proceeds of the sale between the parties. Just real quick before I begin, Pat mentioned there's a couple of course materials in that. I'll reference a couple during my presentation. There's a very basic verified complaint that can be used to initiate a partition action. So it includes the type of information that should be in there. And then I also included some I'll say recent court decisions within the last couple of years surrounding partition actions that hopefully I will have time to go into a little bit more detail about at the end. So next slide, or I'm sorry. Who might need partition actions? So not everyone has the ability to initiate or have standing to initiate a partition action in New York State court. So who might need to bring a partition action? Well, basic answer is co-owners of real property that either own property or have an interest as joint tenants or tenants in common, and who cannot agree on what to actually do with the real property. What does this mean actually in practice? Well, the typical types of parties or clients involving partition actions sometimes include either married, unmarried couples, business partners, friends, siblings, family members of an inheritance of real property, or pretty much anyone. The really common factor of a partition action and people bringing partition actions, as well as those named as defendants, they all must individually hold or be in the possession of real property as joint tenants or tenants in common. No actual possession of the disputed real property is not necessary to maintain an action for a partition. So constructive possession may also allow for standing, whether or not someone's name appears on a title, is going to be acquiring an interest through inheritance. All of those types of situations allow for that individual to then try to bring a partition action. Basic example here, unmarried couple, A and B, they purchase a home together as tenants in common. They each have equal interest in the property, but their relationship, sours and they break up. Now, they're left with a property. Both of them are named to, but they cannot agree on what should happen to the property, whether it should be sold, whether one person wants to remain in the possession, what now? So next slide, please. So what the parties should do now really depends on the final outcome that they desire. And what I mean by that is if either A or B want to continue living in the home, whereas maybe the other party does not, then they both may elect for what's called a voluntary partition. Voluntary partitions, there's no real rule definition of that, but really they're involved in situations where parties either do not want to keep the property or will agree to the sale, but and consent to the sale, but don't know what to do with the actual proceeds. Again, this is really one of the most cost-effective ways for clients, as well as just judicial economy, to try to resolve disputes surrounding co-owners of real property. There's really two common situations where voluntary partition actions are involved in and that I see in my practice. The first is in the context of a voluntary partition where, take that example, A wishes to remain and retain possession over the disputed real property and B does not. In the context of a voluntary position, in these interests, the parties should then consent for A to buy out B's whole interest in consideration for B to remove their name, off of the deed. A basic example would be A removes their name off of the deed of a property that's appraised at $100,000, and B consents to give A $50,000 to do that. Just again, very basic, very general example. The other type of common situation involving voluntary partition actions that I see in my practice are in the context of when both A and B do not want to remain in the possession of the disputed real property, and they will agree and consent to list and sell the real property and then place the proceeds of the sale into an escrow account. In these situations, the parties can elect to either have discussions by themselves, discussions through counsel, discussions through a mediator, court-appointed referee, or a other third party to oversee those sort of settlement discussions as to how the proceeds should then be distributed. Just note, if you're actually in the subject of a partition action and the court is using a court-appointed referee when discussing how to distribute the proceeds of the sale, then that court-appointed referee may make a decision and finding which would then be binding to the parties in the court. Depending on how soured the relationship is between the co-owners, sometimes exploring voluntary partition actions are really easier said than done. I find that parties will tend to argue over the value of the property. They'll tend to argue over what to list the property for. They'll argue over realtors. They'll argue over other types of things that may be just irrelevant to a partition action. Personal belongings, kids, pets, cars. So really navigating these situations is also a lot of times just about client control. It's about just letting them know that really partition action is focused on the subject real property. Court is not focused on other types of things, personal belongings, kids, etc. And really the time in disputes trying to discuss and figure out all of those potential issues, the clients are going to be wasting more money than potentially what they can get out of the actual sale and then distribution from the sale. So, I definitely try to explore the potential for voluntary partition actions with all of my clients. And again, most cost-effective way to resolve disputes. I've seen this actually be very useful in situations where maybe you may have parties who are co-owners of multiple pieces of real property together. Maybe they own parcels in, maybe 5 parcels in one county, or they may own property situated in different counties or even different states. Unfortunately, partition actions, when you file it in court, it's, the county of the court has the authority over the subject property situated in that county. So, if you file a partition action involving a disputed property in Albany County, you can't then try to, bring in maybe another disputed property that the parties co-own together, let's say in Massachusetts, or even, let's say Schenectady County. That requires a separate partition action in the county that the property is situated in. I've also seen, cost-effective ways in practice, again, dealing in situations where maybe the proceeds gained from the sale minus any sort of mortgage or liens that are encumbered on the property, those proceeds are pretty minimal compared to the legal expenses associated with these types of actions, and what the parties are looking at in terms of walking away with a portion of the money. So in scenarios though where both parties either want to continue living in the house, can't decide who wants to remain in possession, or if both do not want to remain in possession and cannot decide on how to go about distributing the proceeds, either 50-50 or something else, then a partition action is the way to go to resolve these types of disputes. Next slide, please. So partition actions, they're governed by statutes. They're governed by Article 9 of the Real Property and Procedures Law, the RPAPL. And there are 2 kinds of partition actions that the law sets forth: partitions in kind and partitions in sale. Now, the origin of partition actions are derived from common law and dealing with actually partitions in kind. Partition in kind are physical splits in the real property that are divided according to each co-owner's particular interest. So, for example, maybe you have 3 siblings who inherited a piece of property from their parents, and they each, are inherited each equal interests in that property. Well, then, each sibling would then receive 1/3 of the property in a partition. So, the court would actually look at physically dividing and splitting the boundaries of the land into equal 1/3 parts. When courts do this, though, it's actually really interesting. The parcel must contain relatively equal quality and quantity when it's distributed among each individual. And really, that's in situations where maybe portions of the whole disputed real property are inaccessible, uninhabitable, encumbered, either maybe by a pond or some sort of structure. Then when the courts look to divide each parcel of the property physically, they must share equally between all of these qualities. So, sibling A can't receive a parcel that is, 90% encumbered and uninhabitable. Nowadays, though, these types of partition actions, partition in kind, are pretty uncommon. I do see them sometimes dealing with situations where maybe the disputed tract of real property includes acres of farmland that have been in a family for a very long time. I see some examples of vacant lots, either purchased through foreclosure actions or some other means. The vacant lots, they can be divided physically by their boundary lines, or in situations dealing with multiple lots or units. So, condominiums, things of that nature, sometimes courts can look to divide maybe a percentage of the multiple lots units, factoring equal quality and quantity to each individual's own separate interests in the property. Next slide, please. So types of partition actions continued. Most common type of partition actions are partitions by sale. They actually must happen when you're dealing with situations where the disputed real property cannot actually be physically divided. Really, residential homes are common perfect examples of these types of partition by sale actions. Dealing situations where couple purchases a home together as tenants in common, having equal interests. They break up, can't agree what to do with the house. Now one party can petition the court and have the court then force a sale of the house and then divide up the proceeds and distribute it to each individual party. However, it's important to note that courts have held that the right to seek a partition by sale is actually not absolute, and it may be precluded where the equities demand. And really, what this means in practice is that when a plaintiff is attempting to file an action for a partition by sale, they must be able to demonstrate what's called a prima facie entitlement to the partition by sale. They must demonstrate, 1, their ownership, 2, their right of possession, and 3, that a physical partition alone cannot be made without great prejudice. Upon doing that, then the court will then allow for the partition by sale. But it's not automatic, again. So it is very, very important, if you are representing a plaintiff attempting to bring a partition by sale, you plead those facts in the complaint sufficiently enough to establish that prima facie entitlement to summary judgment partition by sale. Next section, please. So, filing partition actions. Section 901 of the RPAPL covers standing, covers individuals who may maintain a partition action. Essentially sets forth that a person who holds and is in the possession of real property, again, joint tenant in common, may maintain an action for the partition of the property. Other individuals may also include a person having or holding a future estate or reversion as a joint tenant or tenant in common. In these scenarios, the subject premise, normally cannot be forcibly sold, really because that would cause great prejudice to maybe the individuals who are in the possession of the property, either by actual possession or some other means. Heirs can also bring these types of actions, as well as an executor, executrix, administrator, administratrix. They may also bring and have standing to maintain an action in situations involving when an estate of a decedent is the owner of an estate in common in a disputed piece of real property. Those types of situations, not as common as, the typical, husband, wife, friend or sibling holding actual possession of the property as a joint tenant or tenant in common. Necessary defendants are set forth in section 903 of the RPAPL. Necessary defendants include pretty much every person who has an undivided share or interest in the property that is subject to the action. And they may have an undivided share or interest either through actual possession, constructive possession, inheritance, reversion, remainder, or has an undivided share or interest as an executor or administrator on behalf of an estate. Other types of permissible defendants are set forth in Section 904. These include those that may have an interest, hold an interest or a lien mortgage on the property, whether it be attached to the whole property or a portion of a party's separate interest. Other permissible defendants may also include the state, as well as what the courts allow for and what they call unknown persons. So before I get into the next section, I want to just reference, again, the course material, the basic verified complaints that I included. Feel free, take a look. This is what a basic complaint can look like, the type of information and the facts that need to be pled in the complaint. I'm going to be talking about Section 905 of the RPAPL, which covers what must be included in the complaint. So as I go through it, again, feel free to take a look and reference as I go through. For starters, though, again, just sort of reiterating what I already said before at the beginning, the complaint should be filed in the county that the real property is situated in. Next slide, please. So filing partition actions continued. Again, Section 905 covers what must be contained within the complaint. A basic complaint must include 1, a description of the property with reasonable certainty. 2, it must specify the rights, shares, and interests of each party named in the action. 3, must contain any other allegation required by statute. Now, before this presentation, I tried to quickly look for examples of what, an example of an allegation required by statute would look like. Fortunately, I couldn't find Lunk, but if anyone has any ideas, feel free to shoot that in the question or comments, and I can, present that at the end. But it's important to know that these pleading requirements, again, they may form the basis for the summary judgment arguments for partitions by sale. The court's material, there's a case law in there, recent case law regarding a summary judgment decision where the court declined to allow for a partition by sale because the plaintiff instituting the action did not specify how he became in the possession of the disputed real property. So, these facts, these pleading requirements, are very important depending on the different type of action that you want to bring. Some other types of applicable facts regarding a complaint that you can include in there includes whether there are any parties, shares, rights, or interests unknown to the plaintiff or that cannot be named. If there are any contingent or uncertain shares, rights, or interests, or if ownership interest of an inheritance depends on an executory devise. And lastly, the complaints must also specify whether the parties named in an action own any other types of lands in common. Next section, please. So, interlocutory judgments. Sections 915 of the RPAPL through sections 919 cover interlocutory judgments. A little bit confusing, but essentially, after a partition action is filed, an interlocutory judgment may be made, which would direct the parties that the subject party should be sold at public auction and or physically partitioned according to the parties' respective shares through some sort of disinterested referee. Pursuant to section 915, an interlocutory judgment shall also determine the rights, share, or interest of each party subject to the action involving the disputed property. It's important, again, to note that there's a lot of case law out there regarding when accurate accounting must happen before an interlocutory judgment is issued. Essentially, inaccurate accounting of income, expenses must occur before an entry of an interlocutory judgment. And again, this is often done through some sort of court-appointed referee who will schedule a time. The parties will submit proof, evidence of their interests, their contributions, maybe appraisals, values of the property, and the court-appointed referee would then make findings and conclusions based on that evidence and submit that for the judge. And again, dealing with this situation, court-appointed referees, those findings, conclusions, can be binding on the parties. Next slide, please.
All right, and we've reached our first course code for today's CLE. That is 178221. Again, 178221. Please submit your completed evaluation and affirmation to CLE@tullylegal.com. That's CLE@tullylegal.com.
Okay.
Whenever you're ready.
So, all right. Next section, dealing just basic Uniform Partition of Heirs Property Act. It's actually something that has recently been developed in New York State law adopted by New York, and it became effective on December 6th of 2019. This act is codified in the RPAPL in section 993. It's interesting, I took a quote. The quote here is from the New York State sponsor memo, which really discusses the reason as to why this act was adopted and what was going on in New York that really was the catalyst for this. Essentially, the sponsor memo explains that there was a growing problem involving, and I love this term, predatory real estate speculators. So, essentially people, whether they lived in New York or not, they were, trying to start businesses and get, profit off of, they prey on people who inherited property. So, they would look to purchase someone's recently gained inheritance of, a portion of interest in land, and then attempt to use that purchased inheritance interest to then partition the court to force the sale of the property, which would then, take away the property from any other heirs of inheritance. And oftentimes, these predatory real estate speculators would try to sell the property at a lower price than the actual value itself. Obviously, this also causes issues, especially dealing in situations where, there really is no dispute about the real property, right? A parent passes away and leaves a portion of, or leaves their farmland to three siblings. those siblings may all want to retain possession of the farmland and are not in dispute about it, either, sentimental reasons or business reasons, whatever. Before this act was adopted, one sibling, either if they were strapped on cash or, for whatever other reason, they could sell their interest to someone else, and then that someone else can then use that interest to petition the court and partition the sale of the property. So now, with this act, it provides a couple of due process protections for co-owners of property who are tenants in common. The requirement, though, for this act to be considered is that at least one individual or one party of the action must have inherited their share of the property from a relative. But really, the due process protections now deal with notice, posting a sign on the property, the need for an appraisal, the right of first refusal. The act requires that there are settlement conferences that need to be, initiated right away. And also the act sets forth that a commercially reasonable sale is required and to be supervised by the court. Now, unfortunately, in practice, due to COVID-19 and having cases sort of delayed, there isn't too much case law surrounding, this act and how courts apply this act to partition actions. Some of the beginning decisions applying this act, we see coming out in around 2021. So, we have about 2 years worth. And again, I hope to get to the case law at the end if I have time. But I did include a recent decision where a court, was analyzing and adopting the Uniform Partition of Heirs Property Act in connection with a subject partition action. Next slide, please. So, distributions of proceeds from the sale. This is a pretty robust area of law, and a lot of the case law examples that you see dealing with how courts look to distribute the proceeds, it's a lot of, I don't want to call it outdated, but a lot of the examples maybe you may not, you may be seeing for the first time nowadays. Things along the lines of maybe contributions made through cable, internet, contributions made through maintenance, etc. It's still being developed, but there is a good sort of basis, a generalized basis for what courts look at in terms of how to go about allocating the proceeds. Sections 961 through 981 of the RPAPL set forth how these proceeds should be calculated, paid, and distributed. Basically, the proceeds are defined and based off of the amount gained from the sale of the real property minus any types of liens, mortgages, debts, costs, expenses that are attached, chargeable to the real property, or those incurred through either the sale of the real property, so closing costs, separate real estate attorney costs, or incurred through the actual partition action itself. Meaning court-appointed referees, parties sharing the costs in that, maybe parties sharing the costs in the appraisals, surveys, other types of necessary things that might be required in initiating and litigating these types of actions. Now, ideally, in a perfect world, if the parties contribute equally as co-owners towards the real property, then the proceeds of the sale should be split 50-50. Now, this is not a perfect world, and unfortunately, not often the case. So what courts look at is they look to allocate the proceeds based off of the contributions made between each co-owner. What type of contributions or factors should the courts consider? Well, think equity. Next slide, please. So a court may adjust the equities of the parties in determining the distribution of proceeds based off of any expenditures that are made in excess of an individual's obligation in maintaining and possessing the property. Although a partition action is derived from statute, Article 9 of the RPAPL, courts find that these actions are equitable in nature, which requires a necessary accounting associated with any type of claimed expenditures that the parties are attempting to seek equitable allocation from. So, in bringing these types of partition actions, dealing with clients that maybe are seeking, excess of a 50-50 split, maybe they're seeking something along the lines of a 60-40, 7-30. They must be required and expected to produce evidence and an accounting of those expenditures during the relevant time period, either through invoices, receipts, their own testimony, maybe individuals who perform work on the property that one party paid for, their testimony, but essentially, everything that a party is trying to claim that they expended in excess needs to be accounted for some way, somehow. In Hunt v. Hunt, it's a 2009 decision out of the Third Department. I thought it did a pretty good job at sort of explaining this whole thing. The court noted that a partition action is an equitable remedy in nature, and the Supreme Court has the authority to adjust the rights of the parties so each receives his or her proper share of the property and its benefits. So, in practice, absent any type of ouster, and those situations do occur, and there is case law, regarding that, where maybe, husband, wife, they break up, they still own a property, and, the wife expels the husband from the property and, forcibly removes him. Absent those types of situations, co-owners at joint tenants or tenant in commons should equally bear in the costs that are required and incurred in order to maintain a property. So, what does this look like in practice? Well, this includes, factors such as the nature of the parties' relationship. Again, whether they're both living in the property, whether maybe one is living in the property and the other is not, when these expenditures are made. They might look at disparities in down payments and mortgage payments. Maybe when husband and wife purchase a property, wife pays for the full down payment out of a separate bank account than the husband. Whether such disparate contributions to the property were intended to be a gift. So they look at the nature and intent. So again, when you are trying to claim that your client should be afforded, maybe excess than the 50-50 in terms of the contributions they made, they will look at whether or not those contributions, maybe it'd be cable, Maybe it would be cleaning services, maybe it would be mowing services, things of that nature. The court might look at it and say, husband and wife living together, husband did this, but it was really intended to be a gift. Courts will also factor in the reasonable value of any types of improvements and repairs to the property, and also the reasonable value of any rental payments with regard to an ousted co-tenant. Common example of this is maybe the subject property is a rental property, and one co-owner has been collecting all of the rental money, and the other co-owner has not. Well, that one co-owner who is collecting all the rental money can't double dip and use that rental money on maybe excess expenditures and then try to recover their share of those excess expenditures. So really courts look at how the parties conduct their finances as well. And again, looking at how the claim excess expenditures were made. I've seen courts look at whether or not the claimed money was derived from separate or joint bank accounts, because the court will look at tracking that money. If one party is claiming that it was the money used was separately held, then there obviously needs to be an accounting from that through some sort of separate bank account. Dealing with joint bank accounts, the courts will consider contributions taken from those joint bank accounts as commingled funds, where one party can't then double dip and try to claim excess from those expenditures made from the joint bank accounts. So next section, please. So in practice, what does this really mean? Well, the types of contributions, again, they may include disparities in the purchase price of the subject party and what the courts term as carrying costs. The easiest types of disparities in contributions to consider when maintaining these actions are first looking at, one, whether or not there were excess contributions or disparities made through down payments, maybe over the course of the possession of the property, if there were disparities in mortgage payments, tax bills, insurance premiums and payments. Those types of examples are really the most types of common disparities in contributions. Again, contributions may also include and involve repairs and improvements. But the case law has developed this and requires the parties to set forth a showing that if an individual is trying to recover their excess contributions made claiming where it was involved for repairs and improvements, it requires that party to establish that those repairs and improvements were, one, made in good faith, and two, necessary to preserve or protect the property. Those are very, very important factors. A husband can't go out and renovate, let's say, kitchen countertops or paint walls throughout the house and the bedrooms, and then try to recover money made in those extra contributions, claiming that they were repairs and improvements made. In those scenarios, painting walls are really not necessary to protect and preserve the property. They may factor into an increased value of the property, which the parties will then be able to share equally once the sale of the property happens. But again, the individual can't double dip and try to recover a portion of the money that they're claiming through those types of improvements, and then also enjoy in the enhanced value of the property itself. Examples where repairs improvements are necessary tornado, hurricane, roof blows off the house, roof starts leaking. Obviously, work to repair the roof is necessary to preserve the property. Also, maybe there might be flooding. There may be, issues, with walkways. All of these types of things, are potentially able for parties to recover. In order to do so, though, they must be able to submit proof or evidence surrounding the circumstances of the repair and improvement and establish the need for the restoration work. A party will not be able to collect for improvements that are made for that co-owner's own purposes, own enjoyment. So, I don't know, maybe husband renovating the downstairs basement and, creating his own office. That is a improvement made for that co-tenant's own purpose. And, it may also be made without the consent of the other co-tenant. So again, all of this, must be able to be established through the evidence and proof submitted by each party, either through testimony or, actual documentation. Courts may also look to allocate the proceeds based upon the disproportionate receipt of rents or profits gained from the property by one party over the other. I explained this a little bit, again, dealing in situations where you have a rental property and, individual A is collecting all of the money and then using all of the rental money to then, pay the, internet, cable, national grid, electricity bills, etc. Then individual A can't try to recover money from, the money used from the rental money to make those contributions. Again, the courts look at double dipping, and try to always avoid allocating the proceeds if they feel like some of the allocation would, cause maybe one party to double dip and enjoy maybe, multiple types of distribution of the proceeds. So again, courts look at the nature and intent of a party's contribution, very, very, very fact specific. Next slide, please. So running out of time, gonna try just to go over these decisions real quick. Again, they're in the course material, so feel free, peruse them at your own time. First one I'm going to be talking about is the Arlo decision out of the Second Department in 2022. In this decision situation, the plaintiff commenced an action seeking the partition and sale of a certain real property. The plaintiff alleged to have obtained his ownership interest from a deed that was given by the named defendant's brother, who apparently owned the property with the defendant as a tenant in common, and then sold his interest in the property to the plaintiff. In this case, the courts looked at the Uniform Heirs of Property Act, and after filing the action, plaintiff moved for summary judgment for the partition by sale and for the court to appoint a referee. The Supreme Court denied the motion for summary judgment, and then the plaintiff appealed. The Second Department upheld the lower court's decision and stated that the plaintiff failed to establish its prima facie entitlement to judgment as a matter of law, although the plaintiff asserted that it had acquired an interest in the property from a deed given by the defendant's brother. The plaintiff failed to affirmatively demonstrate a prima facie showing that the defendant's brother had any interest in the property to convey. So a takeaway of this is to make sure to specify the rights, shares, and interests of each party named in the action in the complaint that's being filed. failure to do this may have the action be dismissed altogether, or may prevent the courts from allowing a partition by sale. Next two decisions. Next slide, please. So we have Korn v. Korn. This was a 2021 decision out of the third department. I thought this was a great decision involving consolidations of partition actions when it involves multiple parcels within the same county. The decision didn't focus that altogether. It was just a little portion of the decision, but essentially the third department determined that the lower court did not abuse its discretion by consolidating two partition actions. One, I believe, they were both initiated in separate years, but they found the lower court did not abuse its discretion consolidating the two partition actions because the actions involved a common question of law or fact. And what they explained by this meant is that the common question of law or fact was really the determination of the respective ownership rights between the parties. All of the parties owned, each parcel subject to partition action, and because each parcel was in the same county, the court, was able to consolidate those actions into one. The next case, Maspeth Place Court, is a case out of Bronx County Supreme Court. Again, this is a pretty recent decision applying the Partition of Heirs Property Act. After commencing this action, the plaintiff filed a motion to confirm the report of referee. The court then denied the plaintiff's motion, essentially because they stated that the mandatory provisions of the act were not complied with. The court noted that they shall determine after notice whether the property is heirs property, and if so, they also must determine that the property shall be apportioned in accordance to that statute. Again, Section 993 involves this act. And then the court also held that it is required to hold a settlement conference for the purpose of holding settlement discussions pertaining to the rights and obligations of the party with respect to the subject property. So great recent example right now where courts are actually looking at applying this act, and we're starting to see some case law developed from that. All right, next slide, please. All right, questions. I think we have a couple questions came in. Let me see if I can get to them. I see one, do you suggest getting an appraisal immediately before filing a partition for sale, or once the court action has begun? Generally, I try to recommend getting an appraisal before filing the partition action. When I have a client coming to me saying that, hey, I own a property with, my husband, or, my, someone that my boyfriend, my girlfriend, and we broke up, we can't decide what to do with it. Well, first I try to explore the voluntary partition, and I try to say, okay, do you want to maintain possession? Do they want to maintain possession? Are you guys okay with a sale? And working and figuring those questions out. Assuming, that maybe both parties want to or will agree to the sale of the property, then I would say, let's get the appraisal done. Let's see how much the property is worth before instituting the partition action, and maybe we can discuss and settle out in the case before actually having to file the partition action. So if we get an appraisal done by an agreed upon appraiser, and the property comes back at $50,000, and there's a mortgage for $30,000, then you're looking at a $70,000 potential sale, minus closing costs, etc. Maybe the parties would be walking away with a pot of money of $50,000. If both parties, are fine and agree that they should be, entitled to a 50-50 share of that $50,000, then go ahead and, write up an agreement, and you don't even have to file a partition action. But, that requires the parties to consent and agree on appraisal, which sometimes, and more often the case, they can't even agree on who to use for an appraiser. In these types of scenarios, I always, again, just try to, have those conversations with my client and basically say, look, both parties really should share equal interest in trying to maximize the profits for the sale. So if we're trying to dispute maybe about minor issues, regarding who to use for an appraiser or who to use for a realtor, that will cause them to incur expenses that sort of, undermine the overall goal that both parties should have, is walking away from a sale of a property with the most amount of money in their pocket as possible. So I hope that answered the question. How do courts generally handle attorney's fees of the plaintiff when others do not want to sell? Great question. So generally, attorney's fees considered incidents of litigation and not recoverable. However, there are some instances that I have seen where court-appointed referees do award fees, attorney's fees, or a portion of attorney's fees that are incurred through the partition action itself. But, I think it's really fact-specific and really based off of the court referee. But generally speaking, you shouldn't be looking to, the client shouldn't be advised that they would be recovering legal fees and expenses for the partition action. Another question, what about a corporate shareholder? Do they have standing to bring a partition action? Well, that depends on, the corporate shareholder's individual interest that they may have in the possession of the real property. A corporate entity can have standing depending on maybe how they go about purchasing the property, what's set forth in the deed title, things of that nature. So corporate shareholder can have standing to bring a partition action, but it's really going to be fact specific based off of their individual interests, how they derive their interests, and how they gained possession. Now, another question on top of that, if a corporate owner simply wants to split a piece of property and there is no dispute, does that require an action? No, that does not require an action if all individuals who have an interest or possession in the property also agree that they should split the real property and agree as to how to go about splitting that. If all of the parties involved in a partition action or involved having interest in a parcel of real property, if all of them can agree on how to dispose of the property or what should be done with the proceeds, then partition actions are not necessary to be initiated. Really, partition actions are necessary when the parties can't decide who should remain in the house or when the parties can't decide how to distribute the proceeds between themselves. So one last question, and I know I'm running a little bit past the time. Courts presume 50-50 splits for joint tenants or tenants in common unless one party had made a disproportionate share of the contributions. Do you know what percentage of contributions thresholds courts have rules is necessary for courts to overcome the 50-50 presumption? No. Again, it's just really fact specific based off of the types of contributions that maybe one party made an excess over, the other, involving carrying costs, or also, factors considering, where those types of contributions were derived from, bank accounts, things of that nature. There's really no threshold. And it's really just based off of, talking about money as opposed to percentages. So, again, that's why sometimes getting an appraisal done beforehand, if both parties can agree, that helps sort of the starting point and negotiation point maybe for the distribution of proceeds. Common example, both parties agree, have a home appraised from a certain appraiser. The appraisal comes back at $100,000. The home is not encumbered by any mortgage, lien, etc. Again, 50-50 presumption, but let's say, so 50-50 presumption, 50,000, 50,000. Let's say maybe the wife, again, when they purchased the property, they paid the full down payment, or they made all of the mortgage payments where the husband did not, and they can produce evidence, documentation showing that those mortgage payments were taken out of a separate bank account owned only by the wife. In those instances, then the court would look and try to calculate how much money is claimed in excess. So if, let's say, there was a $50,000 down payment that the wife made, husband did not, husband should be on the hook for $25,000, right? So taking the 50-50 presumption of $100,000, starting point 50,000, 50,000, the wife made excess contribution of $25,000 in the down payment. You take that away from his money, so you're looking at $75,000 for the wife and $25,000 for the husband. Again, just a basic example, but that's sort of what the courts look at and how the courts factor those allocations. But again, I think I'm out of time. So if there's any more questions, feel free, send me an email or provide your contact information with a question, and I'll be happy to try to address that with you after the presentation. So I think that's all for me today.
Thank you, Matt. So moving on to the second course code here. Course code number 2 is 340876. Again, that's 340876. And just a reminder to please submit your completed evaluation and attorney affirmation to CLE@tullylegal.com. Again, CLE@tullylegal.com. And we will return a completed course certificate to you. Thank you to everyone for joining us for today's CLE, and thank you, Matt, for taking the time to present. We hope to see you at next month's presentation. Thank you and have a great day.